A federal judge is blocking the Trump administration from eliminating union bargaining for hundreds of thousands of federal workers at 21 agencies. Now, this all relates to President Trump's March 27th executive order, which exempts many federal agencies from obligations to bargain with unions. Eliminating collective bargaining would then allow agencies to alter working conditions and fire or discipline workers more easily. This could prevent unions from challenging Trump administration initiatives in court.
Joining us now, our chief legal analyst, Colleen Froed. So what we've been able to read is the law allows for this in instances where this could affect national security. That's when the president can make a move like this.
Yep.
What is the argument here, or is this another case of the president says something and Khalifa's legal team says, we'll try to find a way to get there?
100%. How do I get rid of a workforce that can't get fired? Well, you got to figure out a way to get rid of their collective bargaining rights. Well, how do I get rid of their collective bargaining rights? Oh, wow, we found this clause that says if we can point to national security, then clearly it has something to do with national security. We can fire them. So when he sent out their March fact sheet, they listed those 21 agencies that had these employees that had collective bargaining rights already in place. And they were saying that all of these agencies that had anything to connect to the government, I mean, it was cybersecurity stuff. These are things that, I mean, anything could be connected to national security if you're a federal agency. But nonetheless, they picked these agencies and said they all have national security implications. And because such, we're going to cancel and now remove the obligation to have any collective bargaining agreements. And I know for folks that aren't union, that don't have a union history, union past, it might not make sense to them, but I can give it to them in the best analogy that I can. Let's look at the NBA, for instance. If a new commissioner came in and the current commissioner decided to step down, well, there is a collective bargaining agreement in place right now between the NBA and the National Players Association. The new commissioner couldn't come in and say, you know what, I don't think this is in the interest of the game. Right? If the game is the country in this analogy, and I'm going to get rid of this collective bargaining agreement because I just don't think it works best for the game. That wouldn't be allowed. You'd have to let the duration of the contract expire, and then when it would be time to create a new collective bargaining agreement, you can say, we don't want to do this anymore, we want to go a different direction. But you can't stop it in the middle, and that's what they're attempting to do right now. And they're saying, we're mid-season, 30 games in, we don't like this agreement, we're going to get rid of it, and let me know how you guys want to deal with that later, because we point to national security. And what the judge said is you can't point to national security because you don't like the agreement. And that's what happened.
Also in here, Cleve, they're saying this is somehow about speech, workers pushing back on some of the policies. How is collective bargaining and free speech? How do those?
Well, the speech portion is one of the arguments for why the Trump administration is attempting to fire these folks. To be people saying that I have a right to say and do the things that I want to do on the job and have the protections that having a collective bargaining agreement would have me, not being able to be fired as a at-will employee, not being able to be fired for not having cause. Those are the things that collective bargaining gives you. I'm not only an attorney, I've been a former union organizer. I help folks get collective bargaining rights almost in every state in this country. So for me, I'm extremely familiar with this process. If you're saying you're going to remove something that you voted on, that you took probably months to come up and craft, these are the types of things that normally you don't get rid of like this. Typically, you go to some type of arbitration, you go to some type of litigation, because when both minds don't come together. In this collective bargaining agreement, if I'm clear, keeps both sides working together. You want something, they want something. You guys came to an agreement, and now you collectively bargained for that agreement. The definition is in the title. So part of me is confused on now how you come to the table and say these folks, the default for these things, don't deserve to have it. Now, to their defense, the Trump administration has said, well, we didn't agree to most of these things because the Biden administration, on the way out the door, made sure that the duration and the expiration of these agreements would expire after the Trump administration, 4 to 5 years from now.
Well, right there, is there a legal challenge there saying that my predecessor, or does it not matter? The agreement is the agreement.
It doesn't matter. I mean, these are folks that would be on longer term negotiated contracts anyway. Right. Some, I mean, and this is good lawyering, as I mentioned in the last piece, you want folks in the room that are looking at the fine points. If you recognize that you have an administration that's coming in that's going to be anti-labor, that's going to find a way to reduce and to cut costs to the workforce, then you're going to try to put things in place to ensure that that doesn't happen. Well, if you already have a negotiated agreement between the employers and the employee, typically the new boss or the new company isn't getting rid of it. I mean, I gave the sports analogy, but if we took it outside of sports and put it to the private sector, it would be the exact same way. If you come into a location that has collective bargaining rights, you can't tear up the agreement just because you new ownership takes over.
So what happens next? Appeal? I mean, you got federal workers that will stay in limbo. What?
Appeal, obviously, the Trump administration mentioned this the other day in their press briefing, that this is something where you have another rogue judge that's attempting to, create policy. But I think this is something that is put in place that is in line with how the law is supposed to be. The National Labor Relations Board is typically someone that would advise in this situation, and you would be able to bring a hearing before them as well. Well, what did the Trump administration do in that case? They got rid of the members on the National Labor Relations Board, so they don't even have quorum to have a meeting. So when you have a group that has been gutted, that's supposed to maintain and control these types of things from happening, yeah, this is what occurs. So now you remove the National Labor Relations Board, you remove your collective bargaining, now it would be extremely easy to fire and remove workers. Those are the types of things that we're walking into in a situation like this. And so the next step is appeal on the Trump side, but victory short term for the employees.
Yeah.
Khalif, real quick, I do want to ask you, as far as the workload that we're seeing for these, because we keep on seeing these appeals, we keep on seeing, at some point do we get a chance where it's case overload, or is this kind of normal? Can you put it into perspective for us?
Not normal at all. I mean, these folks this is what they do. They're lifelong employees that do litigation, that work and represent the government in these type of cases. So they're going to get a caseload, and they're expected to be there and present and advocate on behalf of their client. In this case, the client is the government. But make no mistake about it, nothing about this is normal. And so while you are saying it's normal for them to defend these cases, the amount, the workload, the saying I'm stretched or I'm thin, specifically when you are diminishing certain departments in those places where you need help in litigation components. I know a number of folks that work for the government, teams that may have had 15 to 20 people are now down to 2 and 3. So the workload is balancing. Now you're trying to do more with less. When you say on the one side you want to reduce the workforce, there still has to be folks there to do the work. And if in this lane your work isn't construction, your work is legal, you are an attorney, you need attorneys to do attorney work. And in this case, if you're going to challenge or be challenged in court, you need to have folks in those hearings, or you're going to have one attorney running from state to state trying to figure it out.
Queen City News Plus. Just search Queen City News on your smart TV's app store.